Hello, Attorney Andrew Bethel here at Bethel Law, where we delve into the dicta of estate planning, finances, real estate, and taxes. And today, I'm going to talk about how not to get sued so I don't have to wear this for another video. Or, I guess from another perspective, not losing your right to sue somebody and therefore forcing me to wear this again for another video. Today's discussion centers around a vital court ruling from California that could have profound implications for anyone involved in managing or inheriting from a trust. It's a cautionary tale that underscores the absolute necessity of having your trust documents in order and ensuring that successor trustees comprehend their legal responsibilities. Or to put it more simply, make sure your documents aren't messy, that your successor trustee knows what they're supposed to do, and if you're a beneficiary, so you don't have to come up with a creative way to circumvent statutes of limitations. Before we dive in, remember to like and subscribe and share the video with, well, anyone facing estate planning decisions. Could save them a world of trouble down the line. Imagine this, your loved one has passed away, leaving behind a trust. You might think everything is settled, but what if there's a dispute over the trust's amendments? Here's where things get tricky and why today's topic is crucial. We're discussing the strict deadlines for contesting a trust in California, highlighted by the recent case of Hamilton v. Green. This ruling reinforces the need for precision in trust management and contesting any amendments. If you know anything about the law or will only take one thing from today's video, it's that the legal world runs on timelines and is full of a lot of hurry up and wait. Let's get into the case itself. In Hamilton v. Green, the Court of Appeals of California made an important decision regarding the 120-day statutory window for contesting a trust. As a reminder, or for those who don't know, once a trustee provides notice that the trust has become irrevocable as a result of someone's death and provides a copy of the trust, the recipient of that notice has 120 days to challenge the validity of that trust before losing the right to do so. Here, grandmother, Lena, had a trust drawn up where she left everything to her two children, LaDonna and Eric Sr. The trust said that if either LaDonna or Eric Sr. were to predecease Lena, that their share was to be distributed to their children. However, there was a later handwritten amendment to the trust in 2002, carrying Lena's purported signature, wherein the terms were slightly altered to say instead of distributing to the grandchildren in the event either LaDonna or Eric Sr. predeceased Lena, it would go to the surviving child of Lena. Well, unfortunately, Eric Sr. died 2 years later in 2004. Lena then died many years later in 2019, leaving LaDonna as successor trustee and sole heir. Now what LaDonna should have done was send the trustee notice and a copy of the trust and amendments to Eric Sr.'s two children within 60 days of Lena's passing. Despite that, LaDonna refused to share a complete copy of the trust or provide the required trustee notice, only sending her nephews Eric Jr. and Dominic snippets of the trust as she saw fit. Well, of course, Eric Jr. and Dominic were not happy about that, and they filed a petition with the probate court to compel their aunt to give them the trust and have her removed as trustee. They did this on January 13th, 2020. LaDonna, probably under advice of counsel, finally provided the requisite trustee notice letter and a copy of the trust and the handwritten amendment to her nephews. She did this on April 17th, 2020. In that notice, it plainly informed Eric Jr. and Dominic that they had 120 days from the day they received that notice to bring an action to contest the trust, which, as luck would have it for LaDonna, they waited a little more than 120 days, something more like 328. It took them almost an entire year to ask to amend their initial petition to also challenge the validity of the trust amendment, which, as a reminder, made it so that due to their father passing before grandma, they as grandchildren received nothing and it all goes to their aunt LaDonna. They alleged their aunt forged that trust amendment. The judge, probably a little annoyed, slapped that idea down, probably telling them that they should have done this 8 or 9 months ago. Eric Jr. and Dominic were not happy again, and so they decided to act a little bit faster and performed their counter on day 142. Now, what do you do when your probate petition to contest a trust claiming forgery is shot down on procedural grounds? Well, get a little creative, you throw your hands up and I'll just sue the trustee for stealing my money and creating false documents. Despite the two boys not expressly asking the court to invalidate the trust amendment, the practical effect of their suit would have been to do so. After all, if the court did not find the amendment valid, then Eric Jr. and Dominic would have no standing to bring the suit in the first place, seeing as how they weren't getting anything from the trust as a result of the amendment anyway. Because the practical effect of their suit was, in essence, an action to contest the trust, the court applied the statute of limitations to perform such an action, which was 120 days from April 17th, 2020, when they received their trustee notice letter, not 470 days later. Let's analyze everything that went wrong here. At first glance, you may only consider that Eric Jr. and Dominic royally dropped the ball in failing to contest the trust within 120 days from receiving that trustee notice letter. They lost on basic procedural grounds. It's not losing a race because you weren't the fastest runner. It's not even getting to participate in that race because you forgot to file the application to run until 6 months after the race occurred. We have no idea whether the trust amendment was in fact a forgery. The court did not make a finding on the validity of the amendment because it was just too late to fight about something like that. Even so, that's the last mistake in a series of mistakes here. Before that, we had LaDonna, the successor trustee and beneficiary of the trust, who's just not following the law, plain and simple. As trustee, LaDonna had a legal obligation, meaning the law says you must do this no matter what, to provide that trustee notice to the natural heirs, even though she was the sole beneficiary of the trust. In addition to that, LaDonna was also legally obligated to provide a complete copy of the trust and any amendments to anyone entitled to receive that trustee notice. LaDonna decided not to provide the requisite notice and not provide a copy of the trust until probably after her lawyer got mad at her, and she allowed for the possibility of being removed as trustee. Going further, the cost of this litigation is something that LaDonna had to pay for, or really Lena's trust estate had to pay for, which means that Lena had to pay for this with her hard work during her lifetime. On the other hand, if you thought Lena was going to escape from this unchided, then you would be sorely mistaken. Lena could have possibly avoided all this headache between her daughter and grandsons by not doing a handwritten trust amendment and instead going to an attorney to have it properly drafted and have this amendment drawn up. An intangible benefit of going to an attorney that people rarely consider is the fact that by doing so, you have an additional disinterested witness to your testamentary intent and capacity. Plainly put, you have more impartial witnesses who can testify that your trust was not the product of fraud, undue influence, or duress. You have the attorney, their staff, and a third-party notary if one was brought in. Yes, Lena saved a few dollars by handwriting her trust amendment at her kitchen table, but her daughter very likely spent 50 times that amount in legal fees. And that's not an exaggeration. Here's some quick key lessons to take from this case. Importance of timeliness. The court emphasized the importance of filing within the statutory period, no exceptions. If you suspect any issues with the trust amendment, acting swiftly is paramount. Underlying the importance of doing things on time, we also have the failure to provide that required trustee notice and trust copies by LaDonna, thus allowing this whole matter to drag on for years. Lena died in 2019. We didn't get this ruling until December of 2023. It took 4 years to say you waited too long. Next, evidence of forgery. Even strong evidence like suspected forgery must be presented within this period. As a reminder, the court did not entertain the validity of the forgery claims due to the procedural timeout. And lastly, implications for beneficiaries. This ruling serves as a stern reminder for beneficiaries to be vigilant and productive. If you're entitled to a copy of a trust and its amendments, review them immediately upon receipt. The best defense against a potential legal battle is a well-crafted estate plan drafted by a knowledgeable attorney. Incorporate clear, legally sound trust documents and ensure your successor trustees understand their duties thoroughly. These measures can protect your estate, ensuring your wishes are honored without a fight. Going forward, remember the story of Hamilton v. Green not just as a legal anecdote, but as a cautionary tale. Don't draft estate planning documents in secret, especially when it involves excluding potential natural heirs. If you're the successor trustee of a trust, then don't try to hide or obfuscate the matter. You are legally required to be open and honest. And finally, if you're staring down the barrel of a statute of limitation deadline, even when as short as 120 days, then don't procrastinate and have to come up with a creative solution to bail you out, because oftentimes they don't. But anyway, what do you think? Do you think that the trust amendment was a fake? Do you think that the grandkids were just trying to get a piece of the pie? Let me know in the comments below. Don't forget to like and subscribe and share the video with someone you think who might enjoy the drama. I'm attorney Andrew Bethel, and I'll see you at our next meeting.